at the scene of the Walenta shooting?
I believe they could.
Okay.
I believe they could.
Okay. Alrighty. And on the refusal to admit the eyewitness ID, can that be harmless?
I'm sorry,
The eyewitness ID expert, excuse me. Can that be a harmless error?
well, we don't believe I think
You
that
don't believe it was harmless, but is it subject to harmlessness analysis?
I think it could be, because it's a question of the admission or the refusal of evidence. So I think it could be. Of course, we think the eyewitness testimony in all three incidents, the Walenta incident, the Schreiber incident, and the capital counts, we think the eyewitness testimony was so important to conviction on all of these that Reginald was denied his right to present a defense when he couldn't present his expert.
Could I get back to Ms. Walenta's statement and the Crawford issue? It's your position that Crawford just precludes a victim's statement or observations, identifications, if that victim subsequently dies or is unavailable? Is there any leeway in Crawford as it pertains to that in your mind?
You may have noticed that we didn't argue that the neighbor's testimony was precluded by Crawford, because Crawford prohibits testimonial hearsay. And, but I think if it is testimonial hearsay, there's no leeway. It has to be excluded unless you can meet the burden of proving this forfeiture by wrongdoing.
That's the exception that would be the forfeiture
Right.
by wrongdoing. There's really nothing else. So Crawford stands for the proposition that a witness's or victim's observation dies with the victim.
Only
deceased.
only if it's in the nature of testimonial
Right.
hearsay.
That testimonial evidence.
Right. Which her identification was, clearly.
Right.
And just a fact question as to the statements made by the husband. You're saying all of those were made, all of the testimony he would have provided was statements that he overheard her saying to police?
Correct.
There was no attempt to have evidence of statements she may have made to him personally?
No. Because that may not have
That
been
may not
testimony.
have been testimony.
But there was no evidence in the record that any of this was based on some private discussion that he had with her.
Okay, I have another question related to the voir dire and who was left on, who wasn't. The state says that the defense left on 5 jurors with opinions on guilt, and that there were no challenges for cause to those 5. Do you disagree with that number or that statement?
I don't.
Okay.
I don't. Because, when the defense was using their peremptories, they actually had 2 things going on. They were trying to eliminate jurors who had strong opinions of guilt that the defense didn't believe that they could put aside, regardless of what the jurors said. But they also had to think ahead to penalty phase. And so they also had to use peremptories in an effort.
I'm talking about challenges for cause.
Oh, I'm sorry.
The state said that the defense left 5 individuals who expressed an opinion about guilt in the panel during the for cause challenges. Said that they were not challenged, they were passed for cause. Do you disagree with that?
I don't disagree with that.
Okay. All right.
Do we know from the record, this goes to the penalty phase, whether or not the jury observed your client in handcuffs? Is there a finding by the trial court that analysis really was never made, was it?
No, and I don't believe that's an issue we raised.
Okay.
That must be one of Jonathan's issues.
Okay.
Because we didn't raise any kind of
Okay.
issue with regard to that.
Any further questions of counsel? Would you like about 30 seconds to wrap up, or do you feel you've made your points?
I believe I've made my points. Thank you, Your Honor.
Thank you.
May it please the court, Kim Parker, Chief Deputy District Attorney in Sedgwick County, representing the state of Kansas, and I am here with Mr. Loudon and Ms. Isherwood. I want to begin. In turn, I will address the issues that counsel raised, but I want to begin with the premise that what happened in Reginald Carr's trial was fundamentally fair. There's no prejudice that came to him by the separation. There's no prejudice that came to him by the inclusion of WB as one of the jurors, and no prejudice or unfairness because of what I would characterize as the red herring of the third-party evidence rule. In this matter, this
Now,
event...
Counselor, Jonathan's attorney on numerous occasions argued strenuously that Reginald was the culprit. How can that not be prejudicial to a defendant when the co-defendant is acting as a prosecutor? Now, it may not have been outcome determinative, but it's got to be prejudicial, at least to his counsel, to be fighting two other attorneys instead of one. I mean, how can you say that's not prejudicial?
Well, it is prejudicial in the sense that it was a restatement of all of the state's evidence that was in fact prejudicial in the conviction of the defendant. Now, it is true that Mr. Evans spent some time discussing the evidence. Most of it he discussed putting into the hands of Reginald Carr the multitude of items of stolen property, which, if you recall, his attorney in opening statement, part of the defense was, yes, I am in possession of stolen property. So much of the argument or focus of Mr. Evans' argument was on that stolen property that Reginald admitted he had.
Did the state put on evidence that Reginald was the reason that Jonathan participated, or that it was Reginald's fault that Jonathan participated?
No.
Because that's what
that.
Jonathan's position was, is that I did this because of Big Brother. And so that's evidence that came. It wasn't just a restatement of evidence. It was additional evidence, wasn't it?
Yeah, his mitigation evidence through family members was leaned toward the idea of that Reginald was the leader of the brothers, that he followed his big brother, yes.
So maybe it's helpful for us to separate for a moment guilt from penalty phase.
Okay.
On this idea of whether what was done by Jonathan and his counsel was potentially outcome determinative for Reginald. And so I think you said nothing that came in from them during the guilt phase or was argued by them during the guilt phase changed the outcome for Reginald.
Yes.
But you would admit that there were certain items of evidence that came in during the penalty phase that were not first put in by the state or eventually put in by the state. Let's use the testimony of Tamika as an example. That's probably the most
Well, yes, it's
evident
probably
example.
the most critical if you want to focus on a piece of
right.
evidence.
Confessions being
The thing
pretty
about
much the most
Tamika's testimony is that she was Reginald Carr, defendant's witness. That when she testified to this statement, there was a pre-question to the, yes, he said he was the shooter, where counsel, Reginald Carr's counsel, would have had an opportunity and notice to object, and no objection was ever lodged, nor ever complained about later. It would be hard to imagine that an attorney putting a witness on the stand would not have already known that and asked for some sort of prophylactic measure. And even when the evidence came in, did not object. And this, of course, then later, in the witness Tamika Harding's testimony, she disclaimed the statement in the state's examination of her, through cross-examination, that she really didn't remember saying that.
Yeah, I think the second time around she said she didn't remember. She
And
didn't say it. She said, I don't remember.
And then Reginald's attorney got back up and then re-emphasized the information, suggesting that did he say he shot all of them or something to that effect. So the part of Reginald Carr's attorney in this matter of failing to object, failing to move for any prophylactic measure, the failure of Mr. Evans knowing throughout this measure that the court was willing to consider any sort of severance issue. He made that part of the record early on. And Mr. Evans made no effort to suggest and allow all the parties to know that he was about to try to introduce this information.
I'm not sure how that factors in. I mean, he obviously kept arguing for severance. That's the record's full of motions to sever. You're saying the fact that he may have sandbagged should make us rule that it wasn't outcome determinative on penalty? I'm just trying to
I would
understand
say
the logical
even
relationship.
in the penalty phase, to consider that single later disclaimed statement to have brought such prejudice to deny
I
a fair trial.
understand that argument. The part I don't understand is the logical link between what Jonathan's counsel's conduct has on outcome determinative. Is there a link there that I'm missing, a logic link?
Not that I know of.
Okay, thanks.
Can we get back to
Ask the question.
the notion of prejudice and the incompatible defenses? And the part I'm having trouble with, Ms. Parker, is that even in light of your, I called it overwhelming evidence to your to counsel, how does the arguments, the cross-examination by Jonathan Carr almost exclusively validates every piece of overwhelming evidence that you have, or not every piece, but a lot of the pieces of the overwhelming evidence you have. And in validating that, how do we measure the impact that that validation has on a juror? Do you have any, can you help me with that? I mean, how do you measure that impact? Because what happens here is that you present your evidence, and a lot of that evidence, at least against Reginald, is going to be supported by Jonathan's cross and Jonathan's arguments and even direct examination. And that validates a lot of your evidence, adds weight to it. How do we measure that as it pertains, or can you help me with that?
I can't, in my own mind, it's hard for me to understand how it could add any additional prejudice because the evidence was already there.
You don't
already
understand
so
why a
overwhelming.
juror might be more persuaded by a brother saying something, that his brother did something, versus a detective saying, we think the evidence shows that? I think when the
that's part-
brother corroborates the state's evidence, that makes it more compelling and more persuasive and more believable for a juror, doesn't it?
Well, I think that's part of the issue here. When you look at antagonistic defenses and you look at the multitude of cases, and the law that the court had to look at is they had to look at what was the evidence. And there is no evidence from the defendant, Jonathan. There is no evidence in this matter.
But-
It is only statements of counsel.
But Counselor,
Which-
Justice Rosen's question is, how do you address the believability factor, the corroboration factor of having the co-defendant in the same trial? I believe that's what his question is, and I haven't heard an answer to that yet.
Well, in this instance, as I said before, and maybe I'm not answering your question in the manner in which you would expect, but as to the antagonistic defense question, there is no evidence. This jury was instructed over and over that they had to decide the case based on the evidence and not upon the arguments of counsel. And so when this second prosecutor, if it's only imagined in the idea that an individual is repeating the state's evidence as opposed to actually introducing evidence, because this jury would be looking at the evidence,
So you're saying
not the
that
arguments of counsel.
you're saying that a witness that corroborates testimony is not evidence. And that's what we have here. We have basically corroboration of the state's evidence. And it seems to me if you have two witnesses that say something happened, That's different than if you have one witness say, and that second witness is evidence.
Are you
It
s-
may be corroboration evidence, but it is evidence, isn't it? You're trying to tell us that corroboration is not evidence.
Are you speaking about a particular witness, the Tamika Harding testimony in the penalty phase? Because other than that, there was no evidence put on by the defendant, Jonathan.
Jonathan didn't plead guilty. He didn't admit to being there, did he?
No.
Right.
In fact, so at the outset and all through the trial, which the court said he would entertain the question of severance, the question before him was whether or not, one, there's antagonistic defenses, and whether or not there would be evidence admitted at the joint trial or excluded at the joint trial that was not otherwise admitted or excluded at the separate trial. And in this instance, nothing was admitted or excluded except for the one statement in the penalty phase from Tamika Harding.
What about the statement that he made in jail? Jonathan made in jail, would that have been admissible at Reginald's penalty, separate penalty?
I don't know why not.
Okay.
Because it was not a surprise if the state had known it, the state could have, as with Tamika Harding. So antagonistic defense question at the beginning for the court and throughout was constantly focused on the idea that both defendants were saying that they weren't there. And no evidence produced by either one that wouldn't have also been different or and analyzed different in a separate trial.
Can I move you over to
Yes.
the verdict form on the A4 capital murder?
Okay.
And it refers to the crimes against the victim, Holly G., for the definitions of rape and aggravated robbery. You know what I'm talking about there. It's any of the capital murder counts. We can just take the one for the victim, Heather M. But you go through what constitutes capital murder, and then at the end, it says the elements of the crime of rape are found in instruction number 37, and those of aggravated criminal sodomy are found in instruction number 39, and you look at those, and those relate to the victim, Holly G. How did that happen when you guys were in the instruction conference? Because you're referencing a victim that lived, and I don't get why each of those capital offenses reference only the definitions in the one instruction. What was the thinking of that?
I think that it was those instructions were put together by the court, but I think the idea is that rather than repeating the elements over and over, that the court would give the elements and let the jury know that those were the elements and could be referred back to those as the elements that were to apply as to each of the victims. Without changing that name. I would admit that it would not have been the best process. However, I think if the court looks at, this court looks at the closing arguments and the detail which each one of those offenses were gone through, there would be no question in the jury's mind, especially after the amount of time they spent listening to evidence and considering that evidence, that there would have been any confusion because of that mistake. In fact, as to any confusion and the conscientious nature of this jury, I think one of the analysis here that this court ought to consider is the fact that this jury, even with the foreperson, WB, was so conscientious in its review of this matter that while it might have been easy to throw Jonathan in the mix on the Andrew Schreiber case, they refused to convict him of that matter because of insufficient evidence. And if you look at the total of that matter, yes, that is the situation, the one case where there was less evidence to convict Jonathan. The idea that this jury was so conscientious in reviewing the instructions and making that finding, in addition to a question that they brought out regarding count 43.
As long as we're on the issue of sufficiency in the various incidents or sets of crimes, I guess is the best way to describe it. Let's talk about the evidence against the two defendants in the Walenta shooting. How it would be sufficient. Right this minute, let's talk about Reginald.
You know, I believe that's an excellent question, because when you look at Reginald in that matter, what you have, and I believe you referenced this earlier, and that is this black gun, this Lorson 380, which all the bullets, fragments, etc., from the three events matched. And that was the gun with Walenta used to shoot into her vehicle 5 times and into her person. That gun, if you recall, or the reading of the record here, that gun was then testified to regarding the witness Tronda Adams, who was the girlfriend of Jonathan Carr. And shortly after this event, Jonathan went to Tronda Adams and made this passage of those guns. And so that evidence, I think, was very important to the jury in determining whether or not Jonathan was more closely tied in that matter than, of course, like the Andrew Schreiber. In addition to that, one of the things that happened in the Walenta case, when we speak about her hearsay testimony.
I really wanted to focus on Reginald, obviously, right now, on the evidence against him in the Walenta shooting.
Yes.
Both the taking aspect of it, and then what we're left with if the statement goes away.
The taking.
There was one issue, and I previously said that what's raised for one defendant can be noticed by the court for the other defendant if it applies. So there was an argument in one of the cases about taking. There was no evidence of a taking or an intent to take anything from Ms. Walenta at the time she was shot. Mm-hmm. So how can you have evidence? How can that be sufficient on robbery?
No, I see.
As the underlying crime for felony murder.
Evidence.
Yeah, sorry, there are a lot of steps there, but you understand what I'm getting at. And then the other assault on sufficiency there was that the ID has to come out, and that doesn't leave enough. I'd like you to address both of those points.
One of the things about joining the counts, joining the cases, would be, is it something that you could join if you were trying to introduce the information via 6455 and to prove intent, motivation, etc. The other crimes show Reginald's involvement with Andy Schreiber with a motivation to rob. I believe there were statements, you've got a nice car, to Andy Schreiber, you must have money, and then they proceeded to take him to ATMs. They came to Andy Schreiber's, Reginald came to Andy Schreiber's window and pointed a gun at him, much like he did in the Walenta matter. This is a situation where she was followed in her SUV into a cul-de-sac by the vehicle where the passenger got out, approached her car. That individual, determined to be Reginald, and pointed a gun at her. Now, this is someone that she testified was unknown to her. And if you understand the commonality between the 3 crimes and the motivation to take property, jewelry, money from a victim, this is consistent with that link, that motivation link between those 3 crimes, that it was in fact for the purpose of committing a robbery. And most individuals applying a common sense and reasonable view of this evidence would be hard-pressed to suggest that there was some other motivation.
Don't you have a real problem, a Crawford issue, though, with much of that identification? You have the non-testimonial statements to the neighbor, but beyond that, what do you have for identification? Assuming that there was a Crawford violation as to the other statements.
Well, as to that, I believe, yes, at the moment of the photo ID, you have some questions as to the testimonial nature. And then with that, I would argue the forfeiture by wrongdoing. Prior to that, we have all statements made to police immediately after, and there were several, and to the witness and also to the defense witness, Janice Sander, or Dander, I believe her name was. She was called by Reginald Carr in the case to point out that he wasn't the one because Miss Walenta had told her that he had some sort of blonde hair, which was different than some of her other descriptions. And at that time, it was introduced into the evidence, the stocking cap that was found in Stephanie Donnelly's apartment that had a blonde characteristic to it. And so we have evidence from several civilians, her neighbor, the ongoing emergency exception recognized in Michigan v. Bryant, but I think that is fairly recent, and recognizes a move by the U.S. Supreme Court to recognize that ongoing emergency exception. So all the statements she made early on, and then this witness produced by the defense, which also corroborates, at least with property found in Reginald's, the apartment he was staying in with Stephanie Donnelly, that showed implications that might be determined by an eyewitness to be blonde hair, because it was blonde on the top of the head.
What about the failure to object to Don Walenta's testimony?
Yes, well, you have that as well. There was no objection lodged at that time.
And so would that preclude that issue from the testimony, or the impact, the hearsay nature of that, from being raised on appeal because it was not preserved?
Yes, I would say so.
Is that true, even though the state, chose to join this crime with the capital case?
Right.
And, our statutory authority to look at issues that aren't preserved otherwise on appeal. In other words, if you had just tried the Walenta case by itself, then you might be able to embrace the lack of preservation. But here you've got, a trial within a capital trial, so don't we have to look even for unpreserved errors as to there? What authority would there be for us not to do that, like we would in any capital case? You see what I'm getting at?
Yes, I agree. I mean, I understand what you're saying. I know of nothing.
Okay, so I mean, I think that's kind of the risk. There are benefits and there are burdens that occur when you join all these crimes together. That may be one of them. I've got a different question, which is on your forfeiture argument. As I understand that law, you only get to embrace the forfeiture by wrongdoing if the wrongdoing is intended to keep the victim from testifying. And what evidence is there of that?
Well, she did say that his face was not covered and that he ran immediately thereafter. And so the suggestion, inference from the evidence, and proper inference, was that was his purpose for shooting her, so that he would not be identified.
Is there a difference in the conduct between the Schreiber crime and the Walenta crime that might lend some credibility to the argument that you just made? In other words, they let Schreiber live.
They did.
And so is the shooting really to stop someone from testifying, or is it because she rolled up her window and refused to be robbed, is what I'm getting at. And so you don't really have evidence that qualifies for the forfeiture exception that you're trying to raise.
Well, her refusal to be robbed, coupled with the fact that he ran, I think indicates his need to avoid prosecution, or he would have, in the Schreiber matter, they had taken him out and left him. If you recall with Schreiber, they caused him to be put face down in the back so that he couldn't see. In fact, most of the time that they were with him, I would suggest that they might have come to the conclusion that he would not later be able to identify them. But in the Walenta case, she was face to face with him. Your suggestion as to the evidence would suggest that somehow he got angry at her, and that's why he fired the gun. And I don't think there's anything in the evidence that might suggest that. The obvious inference is that he didn't want her to be able to identify him later. I think it's a reasonable inference.
Your notion is he was going to pull the trigger as he knew he was going to pull a trigger as he approached the vehicle because he didn't cover his face, is really what you're saying.
I think he was prepared to do so.
Because it's a felony murder conviction, not premeditated.
Right.
I have a couple of questions, counsel, about the arguments on the other side that there are legal insufficiencies in some of the charges.
Could you say that again?
The arguments on the other side that there are legal insufficiencies in some of the charges, specifically the rapes involving the male victims and
yes.
the digital penetration as to HG. Could you address those arguments for us?
Yes. This matter was, of course, litigated underneath. The state argued that this was an application of the innocent agent theory, which is codified in the aid and abet statute. In the charging of this document, the question might be raised, is this sufficiently charged? Is it a rape in the state of Kansas to cause someone else to place their genitals inside an innocent person, inside a female's
Before you
genitals?
get wound up here, looking at the charges, who is the innocent agent?
Well,
For instance, in count 30, you say that one of the males committed an act of sexual intercourse with one of the females, while the male did not consent to the sexual intercourse and the male was overcome by force or fear. So who is the defendant using as the innocent agent?
in that matter, it's the female, because the victim alleged in that crime is the individual who did not consent.
I can
or was
understand
overcome
the
by force or
theory.
fear.
The theory, if we assume that rape is gender neutral and that you can force a female to rape a male, but it's not charged that way. You said cause the male to commit an act of sexual intercourse. How can the victim commit the actus reus of the crime? Because rape has the actus reus and the mens rea, and to me, the innocent agent deals with the mens rea. That if you don't have aiding and abetting if you don't have a crime, but we came up with innocent agent to say even if the actor does not have the mens rea, the person compelling that can't. But that doesn't change the fact that you have to have the actus reus. And I'm not seeing where the actus reus here fits. That you have the victim committing the act and also being the victim.
Is this, I'm sorry, this is the count that suggests HG's digital penetration?
No, this is the rape. This is one of the rape counts on the
This
the
is
men
count
as
30.
victims.
Okay.
And you're saying that Reginald Carr unlawfully caused Brad H. to commit an act of sexual intercourse with HG while Brad H. did not consent to sexual intercourse when Brad H. was overcome by force or fear.
Yes, and that the theory in that is that Brad Haka was the victim of a rape that in that instance where the
Perpetrated by
female was
whom?
used as the instrumentality and innocent agent, both of those things actually, by the defendant, because the defendant is charged as the actor.
I understand what you're
crime.
saying today, but how do you get that from the language? It says, because the language of this says that the male committed the act. You're saying today that the female committed the act, was the innocent agent. And I don't
What are
understand
the
how you
initials?
get...
I'm sorry, what are the initials at the beginning? It just says,
It says that the male committed an act of sexual intercourse with the female, and then it goes on to say the male didn't consent and the male was overcome. And so the way it's charged, you don't charge it as if the female is the innocent agent. That's what I'm getting at, is we're not talking about the theory, it's just the way that it's charged.
well, I may be unfamiliar with this particular count or something, but most of the counts were set out to allege the innocent agent at the beginning, the defendant, Reginald Carr, caused, and then the next initials would be the innocent agent.
That makes both the victim, that makes the victim here, which is BH, both the agent and victim. And you're saying that's permissible under Kansas law?
There are no other initials there?
They are, but not as the next initials, I think, if you read it. You can take a look at it, but I think that's the problem we're struggling with is can the innocent agent and the victim be the same person?
Well, if I could go just straight to the HG digital count.
That's a
Digital
little bit
penetration,
different, but
because if that is not what I thought that may have charged, but in that instance, and yes, I would say so. Let's say, for example, as to a murder, if you were to take a gun to someone's head and say, you have to kill yourself by drinking this poison.
I understand that one.
So why would it not be the same if you cause an individual to penetrate themselves, causing them to commit a rape against themselves under
I
threat of force
I
or
understand
fear?
that one. The one with the male victims is a little bit different. But you think they're functionally the same?
I believe they're functionally the same, yes.
Can we move to the Batson challenge?
Yes.
What in the effort by an African-American defendant to exercise a peremptory challenge on an African-American veneer person is indicative of a discriminatory act based on race? Why did that even pass the first hurdle of indicative of racial discrimination?
In analyzing this matter, I think that the court should think about some of these things. This is a matter where Judge Clark, in an effort to secure the most fair and impartial jury, summons 1,000 people, nine panels of 120 each, spent 19 days in voir dire procedure, both individual and general, and to suggest how at some point in time that he was not acting in good faith in this matter or somehow biased in this matter and trying to find some sort of unfair jury, test the imagination. In this case, we're looking at whether or not, as I understand the defendant's claim, is whether or not he incorrectly collapsed
Let's
the
don't talk
second
about the
and third
defendant's
step.
claim. A Batson challenge is permissible if a party attempts to strike a juror for improper purposes, that purpose being to discriminate on the basis of race. Isn't that
Yes.
the Batson challenge?
Yes. and
Tell
much-
me what raised that issue initially in this case, and then we can move on through what
Okay.
other evidence or statements indicate that the defendant here was trying to racially discriminate.
I think great deference has to be brought to the court in analyzing this question and deciding whether or not this was a pretextual statement, and the final analysis is whether in fact he believed. Testing the credibility of the statement made. And here we have in this situation, when we started at that part of the voir dire process where the challenges were being made, we have the case of State v. Bolton. Because of the court's research, expansive research on most of the questions that came before him, the time that he spent, he brought to the notice of counsel, Mr. Greeno, have you read the most recent ruling by the Kansas Supreme Court on the Batson challenges? And counsel had not. So he said, well, it's State v. Bolton. And in State v. Bolton, it clearly addresses that whole question of whether there's a collapsing, and it states that the final analysis, the court must make that credibility finding. Now, to suggest that this judge...
Credibility The race
Of the-
neutral reasons
right.
justifying the
Yes.
peremptory.
Yes.
Okay, go ahead.
Now,
That's what
this
I
is in the
want to
context of an individual who, during individual voir dire, his level of the death penalty on the questionnaire was 5. It wasn't even on the scale of 7, where they suggested that he was sarcastic, which I would suggest to this court that that is a demeanor question that the court, in fact, and why we give the trial court such great deference. But he starts this analysis with State v. Bolton in mind, a clear reference to all of us that this is what he was referring to.
Let's don't
Then-
focus on the reasons that given to strike. Tell me why that racial discrimination is the underlying reason. I mean, there's no evidence here, or there's nothing to indicate that even if the reasons given for striking that person are not compelling, that doesn't matter. Because you can strike anyone because you don't like the color of their hair, so long as you don't racially discriminate, correct?
Yes, but I think that the court, but you have to
But what is there
decide whether the
here?
court.
What is there here to indicate that the reason was racial discrimination?
One of the things that was happening that seemed in conflict with what the defense had said about the reason for striking was that in the immediate jurors before, they continued to say, we are running out of African American jurors. We'll only have 3 left. We're only going to have 2 left. And then all of a sudden, they switch gears and decide they want to strike this African American juror who in the court's mind is demonstrated by the cause challenge was someone who was very willing to follow all the instructions of the law, which is exactly what any judge may be looking for. So it was a complete switch in the claims that they had made prior to that they wanted African American jurors on this jury. And then they suddenly make this claim that he was sarcastic, which I think if you really look at the entire statement of WB and what he was being asked, why are you in favor of the death penalty? Now, that's a question that would cause most people some thought and pause. And he did. He recognized, all I can say is, why not? And then went further when asked about his reason is because it's the law. He made it clear through his entire examination that his civil obligation was of extreme importance to him. So you have the court recognizing Bolton, you have them making a switch at that point in time, and then also suggesting that this man is somehow sarcastic. And I think that those things, in addition to the whole record, which the court is entitled to look at, where they didn't strike individuals that were much stronger against the death penalty, at 6 and at 7, those individuals were left. So the court's looking at this entire record, which he had moved through all of the challenges prior to that. All the preemptory challenges, watch those occur. In my suggestion to this court is to continue to follow the standard of abuse of discretion standard and give great deference to that trial court judge.
But all the other cases we've had, the defendant has attempted to strike someone of a different race. Do you know any cases we have where...
State.
Huh?
You mean the state has...
The state, yeah. The state has struck a juror that's a different race than the defendant. Do you know of any cases where Batson has been applied to a defendant striking someone of the same race?
Nothing that comes to mind, but it concerns me to suggest that somehow if the defendant is African American, that they can never be biased in their striking of another African American. And I would wonder if the court would not go there.
The question that comes, we get these on occasion on the Batson challenges and the race-neutral reasons given, and we have allowed race-neutral reasons to satisfy the abuse of discretion standard that are just simply not as well articulated as these reasons were given. We've had, I don't like, the juror seemed to smirk. Juror did this, much like the sarcastic and contemptuous tone argument, not coupled with anything else, and we've said, that's race neutral, or it's within the wide latitude. And then to do the opposite,
But I imagine,
but what you're arguing is that's the wide latitude that is given to a trial court, essentially.
well, and I would presume that in each of those instances, the court recognized the courts and gave great deference to
We
the
did.
trial court
We did.
ruling. And so likewise, I would ask that the court do
It's
that.
just going the opposite way. It's going from one extreme to the other extreme, it seems to
One
me.
of the things I believe that you mentioned earlier, and that was, and frankly, I stand on my first argument as to this question. But if you're familiar with Rivera v. Illinois,
Meaning the abuse of discretion standard?
yes,
Okay, and the deference due, okay.
the Rivera v. Illinois case, I believe decided by Ginsburg, actually speaks to the question of the state's the right to the preemptory challenge, and it's not constitutionally mandated, but in that she speaks about the good faith mistake that may have been made in this type of a situation. And hardly imagining, like I said before, that you have a judge who's gone to the trouble of going to this great deal of energy expended in trying to get a fair jury
Can I
is
stop
not
you there for
acting in
just a
good
second?
faith.
Yeah,
if
can I
made a
just stop you
mistake.
there for just a second? Doesn't that case also stand for the proposition that it's up to individual states
It does.
on whether there can be a harmless error standard applied at all when there's been Batson error? It
It
does.
does.
Okay, so let's back up for just one more step, and I want to ask you this. Do you concede that there was Batson error here?
No,
Okay.
I don't
Do you
think so.
think he analyzed pretextual? The
Yes,
third step?
I do.
Where is it in the record?
The reason I think that is because of his reference to making sure all the attorneys present were familiar with the State v. Bolton case. And that case specifically addresses that very issue.
But he didn't even wait for the state to make an argument on pretext. And wasn't it the state's burden to make an argument on pretext in the third
I
step
think
of
it's this,
Batson?
I think I'm not sure it's the state's burden to make an argument. I believe it's the state's burden to prove.
And so the state said
And
nothing.
so if the court can look at everything, whether they're asked for rebuttal or not, in fact, if a rebuttal is required, then actually we're talking about a fourth step for the judge. The Batson analysis and all just say three steps.
Let's review.
The challenge.
The challenge, the reason,
The reason
and
and
the
the
demonstration
ruling.
of pretext for
and
the
ruling,
reason.
yes. And
And the state said nothing about pretext on this challenge, right?
that's true. Except
cut
at the
that off
beginning,
because
at
he
the
just
first
ruled.
challenge was the challenge was, there's no more, this is the last
Right.
African American.
That's the challenge. And then they gave all their reasons. And then the court ruled.
And then the court ruled.
And you're saying because he pointed to the Bolton case ahead of all of that.
And because of the facts and circumstances before him, that other jurors in a like position as to the death penalty had not been struck. As to their continued claim, just previous, that we don't have enough African American individuals on our jury. And this claim of sarcasm with an individual who clearly on the record just intended to follow the law of the court.
Why is that race-based? See, that's part of the problem. I mean, frankly, the state started this by making the challenge in the first place. But typically, when you have a Batson challenge, and it's the state that's trying to defend the preemptory challenge, the state says, they smirked at us when we were sitting at the bench. And so all the defendant's saying in this case is the guy was sarcastic to us when we were asking our questions. So why is it evidence of racial discrimination that the defendant would say that potential juror was sarcastic to us, and it not when the state says the same thing when the shoe's on that foot? So there's that problem. And there's also the problem of whether the court went through the correct steps in order to make the decision that we're supposed to give deference to. And if the court jumped the last step and did not wait for you to try to make your case as to why this was a pretextual challenge rather than just a normal old preemptory challenge because we didn't like the way the juror was acting, then don't we have an abuse of discretion just because the court jumped the analysis and went straight to the end?
Well,
Regardless of
Judge,
whether it could have been defended had the judge done it properly.
I don't think that the statement itself, only itself, was not race neutral. It was a matter of whether or not it could be believed in light of all the circumstances that the court considered. Trial court judges are in the constant situation often of maybe not fully expressing themselves. But in this instance, there is nothing in the record that would suggest that, that you could not give deference to the idea that he considered the challenge, all the information and circumstances before him, and just simply did not believe the reason and suggested in his mind that it was pretextual, given the continued complaint that they wanted African Americans on the jury, and decided in his mind that it was pretextual and it really was a race-based challenge.
Doesn't the fact that they were arguing for African Americans to be on the jury cut both ways? I mean, I think you're asking us to make one reading of that, but everything here, it seems to be, we could come out on a ruling that favors your side, or we could come the others for the defense, but we just don't know. We're really having to read a lot into the thought process of the judge here.
Yes.
And is that appropriate, or as I